Hello everyone, today we're going to see about the introduction insolvency of individual and firms. From the fourth unit, the subject is accounting for partnership. Bankruptcy, as the term implies, refers to the legal status of a person or entity whether it is unable to repay the debts of its creditors. In other words, bankruptcy is a legal process for liquidating the business when the existing debts cannot be paid out of the available current asset. Bankruptcy is not the only legal status that an insolvent may seek. In common, often the term bankruptcy and insolvency are used interchangeably. Insolvency refers to the stage wherein a person is unable to repay the money borrowed from the person or company within the due time on account of the unavailability of sufficient assets that can be liquidated to repay the debt borrowed. Going by the interpretation to the term insolvency, it is only a stage of inavailability to honor and debts due and non an ultimate status of being bankrupt. When the stage of being insolvent is not monitored strictly, then such untapped stage of insolvency ultimately lead to the attainment of the stage of being bankrupt. Applications for bankruptcy. An application of bankruptcy can be made only the below mentioned follows. The rejection of application of initiating the insolvency resolution process, where the proposed repayment plan is rejected by the authorities. In the sacrifice, whether the repayment plan as approved could not be implemented in its re-entry, due to which the entity permanently. The application of bankruptcy is required to be filled within a time span of 3 months from the date of receipt or of the order in any of the aforesaid sacrifice. On this note, the application for intervening the bankruptcy process may be filled by the creditor either solely or in consulting with the other creditors. Application by debtors. The debtor may, on the voluntary basis, approach the concerned adjudication authority for seeking the bankruptcy order if the meets any of the outside scenario. In this case, whether the debtor is a firm, when in such a state, the application of bankruptcy may be filled by either of the partners of such firm. The application as filled by the debtors shall be in the form as prescribed in the code, thereby incorporating within itself the annexures and are highlighting in the code. During the courses of making an application of obtaining the bankruptcy order, the debtor may be also propose the name of an insolvency professional who shall, on the admission of application on bankruptcy act as bankruptcy treasury. It is Next one is application by creditors. Creditors may be make an application or motu basis of seeking a bankruptcy order against the debtor. The application by the creditor shall be in the prescribed format and in the code of supported by the requesting annexure as listed in the session. Once the application of bankruptcy is filled by the debtors or creditors and shall come into effect from the very date on which the application is made and shall case into be in effect on the bankruptcy communicament date. Thank you.